Hello friends, today I will be discussing about 25 important points which a society, means a cooperative housing society and their members should consider at the time of redevelopment of their society buildings, and try to incorporate these 25 important points and details in the development agreement. The society or the members should understand the developer company and should take all the relevant details of the partners or directors of the company. They shall also scrutinize the standing and functioning and working of the developer company and their partners and the directors. Before the society grants the right to develop the property to the developer shall check the title of the society. This checking of the title is crucial because if it is done before execution of the development agreement and it is mentioned in the development agreement that developer has checked, verified and scrutinized the title of the society, then the developer will not be having option to claim or challenge the title at a later stage. Society and the members should clarify about the additional area, corpus amount, monthly compensation, brokerage, shifting, all these what is being given by the developer in view of the development, in view of the redevelopment, also the amenities and all that. All these things should be finalized and cross verified via society and the members with the developer before appointment of the developer. Society and the member should also cross verify the actual carpet area which developer is giving, because the definition of the carpet area is different under RERA and MOFA. So it should be clarified that what would be the area as per the old MOFA, as per the RERA, and what will be the actual carpet area, means the usable carpet area which the members will be getting. What amenities the developer is going to give, that should be clarified. If possible, if developer is not clarifying, it should be mentioned that the amenities will be same as that will be for the new purchasers, so automatically you are going to get good amenities, means the members will get good amenities as the developer is going to give the same amenities to the new purchasers. The number of parking which developer will give to the society should be clarified and defined. Any open space which is remaining in the society shall not be permitted to be sold. It should be a place, it should be the society's property. The society and member should also clarify with the developer about the nature of the construction which is going to be built in. It would be a residential, it would be a commercial, or it would be both. This is an important point which should be clarified before the development agreement is being finalized and should be clarified in the development agreement also. Terrace area should be the same of the plinth area. Now this is important because sometime if the developer wants to sell the terrace flat, then he divides that particular area and give a lesser amount of area of the terrace to the members as a common amenity. So it should be insisted that the terrace area should be the same amount of the plinth area. So the terrace would be equivalent of the same area of the plinth area, means the full terrace basically. Now it should be clarified that all the MAHADA, MCGM, SRA payables shall be paid by developer on time without prolonging the payment of any dues to the government authorities. All these payables will be paid by the developer on time. This will effect a smooth development process for the society. Construction to be carried out by developer at their own cost, risk and consequences. All the taxes including LUC tax, GST or any other tax or any other payment of any nature whatsoever in pursuance of the development shall be borne and paid by developer only. This has to be clarified and specifically mentioned in the development agreement. Now this is very important, guys. Time frame for the development to be finalized. In the development agreement also, this point along with the time frame of the table should be mentioned. Now this time frame means what? I'll explain it to you. You have to define a period within which the developer shall bring IOD, within which the developer shall bring the CC, within which the developer shall complete the number of plinths, within which the developer shall complete the construction, etc. So you are binding the developer to undergo or complete the construction in a timely manner, and you will also get a clarity as to what is the process and progress of your construction, new construction going on. Now if the developer fails to obey this particular table or time schedule, then you should reserve a right to terminate the developer, or in addition to this, you can put a penalty clause also in the development agreement to this effect. All the members of the society should vacate their flat only after the developer obtains the IOD, and the permanent alternate accommodation agreement, means the agreement defining and giving the new flats in the new building to the members, be registered. Also, you should make sure that the responsibility to get the building vacated should be on the developer, so the other members who have already vacated should not suffer if some of the members are not vacating. Development agreement, power of attorney, permanent alternate accommodation agreement should be registered before the society building is demolished by the developer. Society should ask for the bank guarantee equivalent to the construction cost, so that if tomorrow the developer fails to complete the construction, society can invoke the bank guarantee and complete the construction. While going for the redevelopment, society should ask for the approved plan, which give the clarity about the new construction which will be built in by the developer. Now, society or the member should not permit the modification or change into that particular plan which is shown or approved via society without the written consent of the society or the members. Society or members should not permit the amalgamation of the projects, means doing two projects, adjoining projects together without their consent, written consent. Developer shall be restricted to raise the funds by mortgaging the flats of the members or the building land, means the society land. If at all he wants, society can permit to to take the loan on the saleable component, except the land, only the saleable flats, and with a clear understanding that all the dues liabilities would be paid by the developer without putting any burden on the society or the members. The offer which is given by the developer should not be changed if there is any fluctuation in the FSI or TDR or in the policy of the government. If the FSI policy or the policy of the government for the redevelopment is changed and it gives the benefit to the society, then those benefits, or it gives the benefit to the developer, then those benefits should be shared by the developer with the society. It means that if in the going on policy the developer was about to get about to construct 10 floors, and in the change policy or with the new FSI policy, if the developer is able to construct 15 floors, so those additional 5 floors society and developer should share. There has to be a clarity with regards to the defect liability period. Defect liability period clarifies the quality of the construction, and if there is any defect in the construction which could be noticed by the society or members, like leakage or breakage or something like that, then that has to be a liability of the developer to comply the same, or repair the same, or compensate the members or the society for the same. Now, this is very important point, guys. Termination clause. There has to be a termination clause in the development agreement. Now, this termination clause basically should be upon the various points. Some of them would be that non-follow of the table or the timely construction by the developer, as I said earlier. Also, you can mention about the non-payment of the rent or non-payment of any obligation of the developer into the development agreement. If he fails to oblige any of his obligation, then the society should reserve the right to terminate the developer and appoint a new developer to complete the construction. New purchasers who shall be purchasing the flats from the developer would be added as a member to the society provided they proportionately contribute to the funds of the existing society so that they come at the par level with the existing members. If in the project any FSI or TDR remains unused or balanced, then the developer shall not be permitted to sell or transfer the same. Society and members should insist for the possession only after full OC and conveyance, and this shall be done within the stipulated time period as stated by the law. Now, again, this 25th and last point is very important. Society should not be considered as a co-promoter under RERA. This has to be clarified clearly and specifically into development agreement, because in absence of clarity, the society will be considered as a co-promoter and could be held liable for the act or non-performance of the developer in the RERA. If it is being clarified that society is not liable or not bound to obey or observe the RERA provisions and developer is only observing the RERA provisions, then there will be no liability of RERA upon the society or the members. Apart from all these 25 points, it is suggested that the society and the members should check last 3 years income tax record of the developer to consider or to analyze the financial strength of the developer. Also check the completed and ongoing projects of the developer. Society can appoint the PMC, appoint the advocate and solicitors who can give you the proper and best guidance with regards to the redevelopment process and protect and safeguard your interest. Thank you for giving your time. If you have any queries, you can put it in the comment section or you can contact us for any clarification. Thank you once again. If you like the video, kindly subscribe to our channel. Thank you.